Well, the first major rewrite of the Divorce Act in 20 years came down today. Of particular concern are ways to make the messy and often bitter business less traumatic for children involved. Let's find out how that will work. The Minister of Justice is Jody Wilson-Raybould. She joins me from the House of Commons foyer. Thanks for joining us, Minister. How does this help kids through that nightmare of their parents splitting up?
Well, the bill C-78 that we introduced today does many things, but central to this proposed legislation is to put the best interest at the child or of the child at the center, and it details, in terms of a lot of information, factors to consider in, as you say, the sometimes challenging divorce proceedings or separation among parents.
So certainly there's some provisions in here that would allow, say, the child to have more choice of parental guardian, or at least that would become a factor under consideration, or a parent showing a violent temperament, that would be a part of in deciding custody. So can you lower the temperature of this by, is the idea ultimately to get it out of the court and put it into a more negotiating friendly environment?
Well, ultimately, we would like to see a lot of these cases removed from the courts. The bill puts particular attention to out-of-court processes, looking at mediation and other measures that would, as you say, lower the temperature. But we're moving away from language of custody and access, which kind of connote a winner and a loser situation, to focusing on new language around parenting time and parenting orders, and the focus, again, being around the best interest of the child, and a number of factors which in this piece of legislation includes what the child's views are in terms of where they would like to spend their time and the nature of a parenting order, if in fact it's reasonable to be able to ascertain that from the child.
How does this deal with deadbeat parents that may have the means, but they don't have the inclination to support their children? How does this try and get the support they need from parents that might otherwise be reluctant to give it?
Well, I think it's a really good question. It's one of the fundamental reasons why we've put this legislation forward, is to alleviate poverty among children, particularly around the separation and divorce. So it provides, through the amendment of federal legislation, the potential of ensuring that additional information is provided to provinces and territories around enforcement acts and orders, as well as providing access to income levels of individual parents to be able to determine the appropriate level of child support, to ensure as much as we can that children that have been implicated by separating or divorcing parents have the necessary supports financially that they require to ensure that their upbringing is as best as can be.
I'm just curious, there was one mention in the bill, the backgrounder I was reading, that talked about that, a violent, domestic violence would be a consideration. Good grief, wouldn't it be a consideration now if one household, if one parent was showing violent tendencies? Wouldn't that be something that a divorce proceeding would already take into account?
Well, absolutely, and judges across the country certainly would take into account a history of violence, domestic violence, but it's not specifically mentioned in the current Divorce Act. So we would make that very clear in this proposed piece of legislation, providing a definition around domestic violence and various factors and situations with respect to domestic violence, but also making it a requirement for a judge or an out-of-court process to take into account protection orders that might exist, criminal proceedings that might be underway, to ensure that the most appropriate parenting orders are put in place.
All right, interesting. I can't let you go without one quick question on the BC government heading back into the courts. They're challenging the constitutionality of Alberta's power to turn off the taps. Do you see the federal government doing an intervention on this one as well?
In terms of the reference case to the Supreme Court, yes, the federal government is going to intervene in terms of the TMX or the provincial government's reference. As we've stated all along, as the Prime Minister has stated and ministers, we're clear on our jurisdiction around interprovincial pipelines, and the federal government is intervening. There has been one case management discussion thus far, and that will proceed through the normal courses.
Right. Well, no, this was the one today. The BC government said they're going to challenge Alberta's right to turn off the taps to BC specifically, saying that's unconstitutional. I don't know whether you see a federal involvement in that particular case as well.
Oh, sorry, I misheard you. But in terms of the decision or the announcement of the BC government, that's something that certainly we will consider and perhaps have an update for you in the near future.
All right, Minister Wilson-Raybould, always a pleasure having you on. Thank you.
Thank you.